start by apologizing for not being able to talk to you in French. It's a lovely language, and I know you will thank me for that time. Also, it's a great pleasure for me to talk to you after being introduced by my very good friend Bernard Duane. As you can see, in human rights work, we make very good friendships, even though sometimes they embarrass us with too lavish praise, undeserved praise. All I can say on that is that the respect and admiration is very mutual. I am blessed for having been able to work with Bernard Duane for many years and hope to continue in that vein. I also want to thank AGIDD-SMQ for this wonderful opportunity to come and talk to this audience about the work that I did as a special rapporteur on torture with regards to torture in healthcare settings, a report that I published in 2013. It's a great privilege and an honor for me to have accepted this very kind invitation. Conceptualizing abuses in healthcare settings as torture or ill treatment constitutes part of an ongoing paradigm shift within the normative discourse and framework of the prohibition of torture and other ill treatment. Recognizing that human rights abuses of a medical nature could amount to torture or other ill treatment in international law is not new. But continually evolving standards have meant that the definition of torture and ill treatment has developed to encompass an increasing number of practices and circumstances that the public doesn't necessarily associate with torture. We sometimes tend to think of torture as happening in interrogation only, or in brutality and repressing demonstrations. But the definition in international law of torture is much broader than that, and it was high time that we recognize that there are certain practices other than those that I mentioned that also compromise the responsibility of the state for both preventing and then investigating and punishing the crime of torture or other ill treatment. Today, there is growing consensus that torture and ill treatment in healthcare settings can and frequently do occur in various forms. Denial of pain treatment, for example, compulsory detention, discrimination against LGBTI persons, reproductive rights violations, and abuse of persons with physical or psychosocial disabilities. In applying the torture and ill treatment framework as elaborated in Article 1 of the United Nations Convention Against Torture to healthcare settings, it is important to note that the definition of torture contains at least 4 essential elements. Torture consists of an act inflicting severe mental or physical pain or suffering. There must also be an element of intent, as well the intent in the sense of the intent to inflict pain and suffering with whatever motivation, and separately an element of purpose. It could be the specific purpose of obtaining a confession, or also of giving leads to other people, but it also can be the purpose of inflicting, punishing, or of subduing somebody for other purposes. What's important is that if the purpose is in itself discriminatory on any basis, it's prohibited by international law. And finally, torture requires the involvement of a state official, at least, if not directly involved, at least by acquiescence on the torture committed by non-state actors when the state has an obligation to prevent it. Acts that fall short of meeting these elements, or where the pain and suffering is less severe, nevertheless constitute cruel, inhuman, or degrading treatment or punishment as enshrined in Article 16 of the Convention, and it's absolutely prohibited, just as torture is absolutely prohibited. In the context of healthcare and the treatment of persons with disabilities, it is important to note that the intent required for an act to constitute torture under the Convention can be implied where a person has been discriminated against on the basis of disability. When it comes to the required specific purpose element, it is also notable that the purpose is explicitly elaborated in Article 1 of the Convention, such as obtaining a confession or inflicting punishment on another person, are not exhaustive, because any purpose satisfies the definition if it involves discrimination. In any event, the non-exhaustive list of purposes do indicate that the nature of specific purposes that would meet the nature of specific purposes that would meet the definition of torture. The Committee Against Torture, which is the authoritative body that interprets the Convention, from time to time publishes general comments on how to understand the content of the Convention. And in its general comment number 2, expressly addressed state obligations when it comes to torture and ill treatment in healthcare contexts. In that comment, the committee stated that state parties are obligated to prohibit, prevent, and redress torture and ill treatment in all contexts of custody or control, including hospitals and institutions that engage in care of mental patients or the disabled. The state's obligation to prevent torture applies not only to public officials such as law enforcement officers, but extends also to doctors, healthcare professionals, and social workers in both public and in private hospitals, institutions, detention centers, and other facilities. States' obligations also entail a duty to exercise due diligence to investigate, prosecute, and punish acts of torture and ill treatment perpetrated by non-state officials and private actors. The UN Committee on the Elimination of Discrimination Against Women, which is another authoritative body, in this case interpreting the Convention on Elimination of Discrimination Against Women, has also suggested that when states outsource their medical services, they nevertheless maintain the duty to regulate and monitor these private healthcare institutions and are directly responsible for the actions of the institutions. It is also recognized that states have a heightened obligation to protect vulnerable, marginalized individuals who are often at greater risk of being subjected to torture and ill treatment. This population of vulnerable, often marginalized individuals includes those living with intellectual and psychosocial disabilities. Despite numerous state obligations to prevent, punish, and redress torture, acts of torture and ill treatment are common in many healthcare settings. Individuals living with disabilities are frequently subjected to non-consensual medical procedures that amount to torture or ill treatment because of the severe pain and suffering inflicted, even if the purpose is therapeutic and not punishment. These individuals are also often compulsorily detained in so-called drug treatment centers, subjected to forcible sterilization and abortions, placed in solitary confinement, and involuntarily committed to institutions or treatment centers. Many of the aforementioned acts of torture and ill treatment inflicted on persons with psychosocial disabilities in healthcare contexts are fundamentally related to issues surrounding legal capacity and discrimination. The Convention on the Rights of Persons with Disabilities, which is one of the more recent treaties in international law at the United Nations level, offers the most comprehensive set of standards on the rights of persons with disabilities, and it is important that states review the anti-torture framework in relation to persons with disabilities in line with the Convention on Rights of Persons with Disabilities, the CRPD. When it comes to legal capacity, the CRPD affirms in its Article 12 that persons living with disabilities have the right to recognition everywhere as persons before the law. Article 12 also requires that states parties recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life, and that states must take appropriate measures to provide access by persons with disabilities to the support they may require in exercising that legal capacity. In its general comment number 1, the committee of the CRPD recognized that it is important to provide safeguards in order to ensure the respect of the person's rights, will and preferences, and to provide individuals with protection from abuse on an equal basis with others. The committee emphasized that even when, after exerting significant efforts, it is not practicable to determine the will and preferences of an individual, here I'm quoting, the best interpretation of his or her will and preferences, end quote, must be placed, commonly resorted to best interest, quote unquote, determinations. Eliminating the determination of best interests is essential to ensuring that persons with disabilities enjoy the right to legal capacity on an equal basis with others. Moreover, the general comment clearly provides that states parties must respect the legal capacity of persons with disabilities to make decisions at all times, including in crisis situations, and notes that states have an obligation to provide support for decisions regarding psychiatric and other medical treatment. In other words, the first obligation is to support the decision-making of the person directly involved and not to substitute it for someone else's. Although the CRPD has been ratified by 177 states and incorporated into the domestic legislation of some of these states, millions of persons living with disabilities across the globe are stripped of their legal capacity on account of societal stigmas and discrimination that are crystallized in law and regulation in the domestic jurisdiction. This process is often carried out through judicial declarations of incompetence or merely by a doctor's decision that the person lacks capacity to make a decision. Once deprived of legal capacity, persons with disabilities are then assigned a guardian or other substitute decision maker whose consent will be deemed sufficient to justify forced treatment. Simply stated, fully respecting each person's legal capacity is an integral first step in the prevention of torture and ill treatment. As I discussed in my thematic report of 2013, persons with disabilities are particularly affected by forced medical intervention and continue to be exposed to non-consensual medical practices, some of which amount to torture or ill treatment under international law. Individuals with psychosocial and intellectual disabilities frequently experience powerlessness and are stigmatized, which facilitates the potential occurrence of abuses. The wide range of abuses committed against persons with disabilities in healthcare settings under medical supervision are often justified on the grounds of medical necessity. However, medical treatments of an intrusive and irreversible nature, if they lack therapeutic purpose or whose curative effects are dubious at best, constitute ill treatment when enforced or administered without the free and informed consent of the person involved. Only when a situation rises to the level of a life-threatening emergency and where there is no disagreement regarding the absence of an individual's legal capacity may a healthcare provider perform a life-saving procedure without first having secured the patient's prior informed consent. Although many treaty bodies and rapporteurships within the United Nations have unequivocally established that involuntary treatment and other psychiatric interventions in healthcare settings can constitute torture or ill treatment, the domestic legislation in many countries still permit such interventions. National laws in countries across the world still allow for non-consensual medical intervention when such intervention is deemed, often by medical personnel, to be in the so-called best interest of the person concerned. These best interest interventions jeopardize the autonomy and dignity of persons living with disabilities and should be revised in line with the standards set out in the CRPD. Furthermore, the imposition of solitary confinement of any duration on persons with psychosocial or intellectual disabilities constitutes cruel, inhuman, or degrading treatment, and depending on the duration, can even constitute torture. My report also argues that using restraints of any kind on individuals with disabilities, even for short periods of time, may constitute torture and ill-treatment. It is essential, therefore, to establish an absolute ban on all coercive and non-consensual measures that are based exclusively on discrimination against individuals with disabilities, including restraints and solitary confinement of people with these disabilities. Such a ban should apply in all places of deprivation of liberty, including in psychiatric and social care institutions. Put another way, the fact that a person is diagnosed as having a psychosocial disability should not by itself be enough to justify non-consensual treatment, including the use of restraints. The environment of patient powerlessness and abusive treatment of persons with disabilities, in which restraint and seclusion is used, can lead to other non-consensual treatments such as forced medication and electroshock procedures. Around the world, persons living with psychosocial disabilities are often either neglected or involuntarily detained in psychiatric and social care institutions, psychiatric wards, prayer camps, secular and religious-based therapeutic, boarding schools, boot camps, private residential treatment centers, or traditional healing centers. Many persons living with disabilities spend their entire lives within the confines of those institutions and are routinely denied basic human rights. Involuntary commitment of this nature should only be permitted under very narrow circumstances, for a limited time and within limited means, as strictly required to prevent the risk of major harm to self or to others. Otherwise, an absolute ban should be imposed by states on all forced and non-consensual medical interventions against persons with disabilities, including practices such as the non-consensual administration of psychosurgery, electroshock, and mind-altering drugs, the use of which can amount to torture or ill-treatment. Deprivation of liberty on the grounds of psychosocial disability is unjustified if its basis is discrimination or prejudice against persons with disabilities. In determining whether deprivation of liberty that is based on the grounds of a disability and that inflicts severe pain or suffering could fall under the scope of the Convention Against Torture, factors such as fear and anxiety produced by indefinite detention, the infliction of forced medication or electroshock, the use of restraints and seclusion, the segregation from family and community, amongst others, should all be taken into account. Individuals living with disabilities are disproportionately subjected to forced and involuntary sterilization and abortions. When these practices are carried out by state officials in accordance with coercive family planning laws or policies, they may amount to torture, as these practices often specifically target marginalized, disabled women based on discriminatory notions that they are unfit to bear children. As the CEDAW and CRPD aptly stated in a joint statement, the committees of the CEDAW and CRPD, in a joint statement issued in 2018, and I quote, "States parties should ensure non-interference, including by non-state actors, with the respect for autonomous decision-making by women, including women with disabilities, regarding their sexual and reproductive health well-being, and health policies and abortion laws that perpetuate deep-rooted stereotypes and stigma, undermine women's reproductive autonomy and choice, and should be repealed because they are discriminatory." End of quote. In writing my 2013 report on torture in healthcare, my goal was to generate and contribute to a discussion about the application and implementation of human rights standards in relation to situations arising in the context of healthcare. I realized that some of the positions that I adopted in my report were contentious, and I regret that some inartful wording may have given rise to misunderstanding of some of the statements included, and that a few of the passages can be legitimately read as contradictory with other passages. For different reasons, my report sparked debate among practitioners, lawmakers, and institutions, such as the American Psychiatric Association and the World Psychiatric Association. Immediately following the release of my report, the APA and WPA sent me a joint statement in which they expressed concern about the definition of torture potentially encompassing a range of practices employed by psychiatrists, such as the use of involuntary civil commitment, the provision of treatment delivered under the auspices of guardianship, and other currently accepted legal processes, and the use of restraints. The organizations also expressed concern that the adoption of perspectives and recommendations that I included in my report, as they relate to medical necessity, involuntary treatment, and other psychiatric interventions, the use of restraints, involuntary commitment to psychiatric institutions, and other instances of involuntary hospitalization, could ultimately be detrimental to the interests of individuals with serious mental disorders and would likely cause serious harm to those very individuals. I welcomed the APA and WPA's efforts to engage my rapporteurship in a detailed conversation about my 2013 report. In my response to their joint statement, I noted that my thematic reports are not meant to be read as the ultimate word on the international law governing the issues I choose to cover, but rather to initiate a discussion about what international law should provide for regarding those matters. My thematic reports also recognize that normative frameworks should change to reflect evolving social standards, scientific advances, and professional improvements. In that response to the APA and WPA statement, I embraced the opportunity to clarify a few of the statements that I made in the report, noting that I did not mean to propose an absolute ban on non-consensual intervention under any and all circumstances. I meant to restrict my condemnation to non-consensual treatment based exclusively on discrimination against persons with disabilities. In other words, the fact that a person is diagnosed as having a psychosocial disability should not by itself be enough to justify non-consensual treatment. Unfortunately, in many countries that is standard practice, often validated by domestic courts and even by international tribunals. Additionally, as the APA and WPA pointed out, my report does acknowledge that some forms of involuntary detention and treatment can be legitimate if the purpose is to prevent the patient from harming him or herself or causing serious harm to others, as long as these methods, non-consensual methods, are used only for the limited time and scope necessary to prevent such harm. I firmly believe, however, that legislation should be revised to place the burden on the state to justify each decision to apply non-consensual treatment under such very narrow grounds. In order to expand, in order to expand on the recommendations I made in my thematic report and to elaborate on and analyze contentious issues, pitfalls, gaps, as well as the implications and consequences of implementing the recommendations contained in my report, I invited experts and practitioners to submit scholarly articles reflecting on my report. These reflections are compiled in a publication entitled Torture in Healthcare Settings, Reflections on the Special Rapporteur on Torture's 2013 thematic report. And that volume includes the letters from WPA and APA and my response to it. The articles address topics ranging from interpretative and guiding principles and the evolution and application of lack of legal capacity as a doorway for torture and other treatment, compulsory detention for medical conditions, persons with psychosocial disabilities or intellectual disabilities, special protection of minority and marginalized groups and individuals as a critical component of the obligation to prevent torture and other ill treatment, and reproductive rights violations. In conclusion, forced treatment and commitment should be replaced by services in the community that meet needs expressed by persons with disabilities and respect the autonomy, choices, dignity, and privacy of the person concerned. States must revise the legal provisions that allow detention on mental health grounds or in mental health facilities, and any coercive interventions or treatments in the mental health setting without the free and informed consent by the person concerned. Fully respecting each person's legal capacity is a first step in the prevention of torture and ill treatment. That, I think, this last paragraph that I read reflects what I think is the present state of international law in the matter, although I have to admit that the change is very recent and it's in a state of flux. So in the next couple of years we may come up with another more serious set of standards. I also want to say that not every expert on international law agree to the letter of what I just said. And maybe in the question and answer period I could expand a bit on where the present discussion is between the different organs of human rights protection and experts on both healthcare and the prevention and punishment of the crime of torture. Thank you very much, and I look forward to your questions.